get started. My name is Kelly Weiss. I'm the Executive Director of Marketing and Communications here at the Law School. It's great to see everyone here to discuss, after the decision, the fall of Roe v. Wade and what comes next. We have a great panel of faculty here. I'm going to introduce them in just a second. Before I do, this is being live streamed right now, and there will be a recording of the event afterwards if you want to see that. So I'm going to start with our panel here. I'll introduce them, and then we're going to have Professor Tang kick it off. But here we have Professor Catherine Flory, Professor Elizabeth Joe, Professor Courtney Jocelyn, Professor Erin Tang, and Professor Mary Ziegler. And I'm going to ask Erin here to start.
Hi, everybody. Dobbs versus Jackson Women's Health Organization is probably a case that needs very little introduction. I'll just do my best to describe the very bare basics before I get out of the way to listen to this incredible panel of experts. Okay, so as you know, for 49 years in America, pregnant people had the right to decide whether to carry their pregnancy to term up to the point of fetal viability, which is the moment when a fetus can survive outside of the womb at roughly 24 weeks in pregnancy. So the Supreme Court first recognized that right in Roe versus Wade in 1973 and reaffirmed it in Planned Parenthood versus Casey in 1992. Between those two decisions, Casey and Roe, a total of 15 Supreme Court justices cast votes on the right to abortion. 11 of those 15 justices voted either to affirmatively recognize a right to abortion or at least to reaffirm the right to abortion under principles of stare decisis. And that supermajority was not, some partisan hack job. Of the 11 justices who voted in favor of a right to abortion, 8 were Republican appointees. So this past June, in Dobbs, 5 new Republican appointees voted to overrule Roe and Casey, calling the reasoning used in those cases by Rockford conservatives like Warren Berger, Lewis Powell, Potter Stewart, Senator Day O'Connor, and Anthony Kennedy, not just wrong, but egregiously wrong. So according to the new conservative majority, Roe and Casey were wrong to strike a balance between the right to abortion, reproductive autonomy, and the state's important interest in protecting fetal life. Roe and Casey were wrong, the new majority said, to erect this framework that allowed the state significant discretion to encourage and persuade pregnant individuals to carry pregnancies to term, significant discretion to try and protect maternal health, but ultimately leaving the choice, the final choice, whether to carry the pregnancy to term in the hands of the pregnant individual for the first 24 weeks. Okay, so why did Dobbs say Roe and Casey were wrong? Well, Dobbs is, if you've looked at it, an awfully long opinion. There are a lot of arguments. But in the end, actually, Justice Alito, in writing for the majority, lays it pretty bare for all of us to see. Right? In his words, the quote, most important historical fact that led the 5 justices to overrule the right to abortion was, quote, how the states regulated abortion when the 14th Amendment was adopted. Justice Kavanaugh repeats that in a separate opinion. He says the dispositive point for him and the other justices is that, quote, abortion was largely prohibited in most American states as of 1868 when the 14th Amendment was adopted. Right? So that the reasoning, in other words, the Dobbs majority's rationale goes something like this. Roe and Casey grounded the right to abortion in the 14th Amendment, which guarantees an individual right to liberty that a state cannot take away without due process of law. Of course, liberty is a capacious, vague word, so the Dobbs majority says to know if that encompasses a right to abortion, we had to look at the liberties that were widely recognized around the United States in 1868 when the 14th Amendment was ratified. We have to ask, in other words, in the majority's words and Dobbs' words, if the liberty interest in abortion was deeply rooted in history and tradition, specifically as of 1868. And looking out at the state of state law in 1868, Justice Alito counted up what he thought were 28 states, 28 of the 37 states then in the Union, right, so that would be a pretty big majority, that he said banned all abortions throughout pregnancy, right, which is evidence that there was in fact no deeply rooted history or tradition of abortion in 1868, in his view. Never mind, of course, that women in 1868 could not vote, or in many instances own property or even enter into contracts. Never mind that the entire movement to codify state bans on abortion It was actually quite novel. It was a new product of, frankly, an openly misogynistic movement by an all-male medical profession that was engaging in what we could call cartel-like behavior to drive out nurse wives and other medical practitioners. Never mind that the 28 count itself was wrong, or at the very least hotly disputed. Right? Many of the states on Justice Alito's list actually didn't ban all abortions throughout pregnancy, as he asserted. Many actually continued a centuries-old practice of allowing abortion for the first 16 to 18 weeks of pregnancy, up to the point of quickening, which is the first noticeable movement of the fetus. Right, so in other words, Dobbs is not, I would say it's not a decision that's grounded in some neutral inquiry into what history and tradition actually looked like in the United States in 1868. It's grounded in something else. I will stop now, though, and turn it over to the others, but I just want to say one thing as we work through today. If we have time, obviously encourage us to talk about what's next in the battle over reproductive justice. That should be the focus. But we should also think a little bit about what's next in the battle over the future of the Supreme Court. Because Dobbs makes one thing clear, and that is those two things cannot be separated.
Yeah, I think I'm next. So I think I'm torn about what to talk about, but because since I'm a historian, I really am going to hold back my impulse to talk about what happened in the Supreme Court because I'm going to look about that. But what comes next, just on abortion, history is a good guide to that too, because the anti-abortion movement was never about Roe being overturned. It was always a fetal person movement. So when the movement arose in the 1960s, it was in response to states like California passing very modest reforms to their existing abortion laws, usually to allow abortion in cases of rape, incest, certain fetal abnormalities, and threats to the health of the pregnant patient. Anti-abortion groups that mobilized to oppose these laws, and sometimes also laws that contained exceptions for the life of the pregnant patient, argued essentially that these laws were unconstitutional. In other words, abortion itself was unconstitutional because it denied equality and due process to a rights-holding person, and that the term person in the Constitution applied before as well as after birth. So in one way or another, the anti-abortion movement's goal will always be, and still is, some kind of nationwide personhood solution that would prevent states like California from allowing abortion. The idea that this was about democracy, or that, as Brett Kavanaugh put it, that somehow the conflict would simmer down if the court simply got out of the way, is naive both in the sense that this was not about the court, and that, of course, the courts will be right back in this because of what states are doing. So I think the kind of dream solution for the anti-abortion movement is either a personhood executive order, which has already been floated by the group Americans United for Life, some kind of nationwide statute banning abortion, either at 6 weeks or at gestation. We've already seen versions of this proposed by groups like Students for Life. What exactly abortion is in these statutes is also hotly contested. Students for Life, for example, takes the position that any form of chemical contraceptive, including the birth control pill, is an abortifacient, and so their bans on abortion would sweep in many FDA-approved contraceptives. And ideally, I think the dream solution is that this Supreme Court, a few years down the road, draws some kind of conclusion that the rights of fetuses are deeply rooted in our history or tradition, or that the authors of the 14th Amendment would recognize as a rights-holding person an unborn child, as Justice Alito would put it. That's not likely to happen in the short term. Justice Kavanaugh, among many other things, flagged his view that the Constitution is scrupulously neutral. So now we're seeing efforts by states to regulate what happens in their borders. Some of you have heard of trigger laws, which are banning abortion. These are not just your 19th century era bans that Professor Tang was talking about. These have much harsher penalties than anything we would have seen in the 19th century, including life in prison. We're seeing efforts, novel enforcement efforts, because of course it's one thing to ban an abortion, it's another to actually prevent people from having them, especially in an era where you can get abortion pills on the internet, including from abroad. So as Professor Flory is going to lay out, some states are trying creative solutions to prevent people from traveling to get abortions, to prevent people from purchasing pills from states or countries where abortion is illegal. Other states are trying instead to regulate on the border between speech and conduct, defining as aiding and abetting or criminal conduct, anything from providing information about abortion, providing referrals about abortion, even hosting a website that contains information about abortion. So the network of people who could be caught up in this criminal dragnet or this kind of redefining of the line between speech and conduct would include not just people performing abortions, but people helping other people having abortions, people contributing to abortion funds, and even corporations, right? We've seen states threaten CEOs of corporations like Lyft with felony criminal punishment for funding out-of-state travel for their employees. So in short, it's a mess, it's chaotic, and if there's anything you can be sure about, it's that the Supreme Court sort of hoped for reality where this all goes away and we just hold hands and sing is not manifesting itself anytime soon. So with that, I'll turn it over to Professor.
So, as Professor Ziegler was saying, there's this drive on the part of the anti-abortion movement for some sort of nationwide legislation. And when you think about it, I mean, one reason why is that, especially in our current world where, it's possible to obtain pills to end your pregnancy, you don't necessarily need to go through a surgical procedure, it's very hard to confine abortion within state lines. Obviously, it takes time and resources to travel to another state. Not everyone's able to do that. Not everyone has access to pills. But enough people are as to really significantly undermine abortion bans. And certainly prior to Roe, people often travel to other states to end their pregnancy, and it's occurring now too. So some states that have strict anti-abortion policies are already taking action or are contemplating actions to basically try to extend their policies extraterritorially and either impose criminal sanctions on someone leaving the state or someone assisting a person in leaving the state to end a pregnancy, but also civil liability, which I think in some ways is an even easier route to discourage, especially doctors, I think, who are really worried about liability in other states because it can have impacts for their career, to discourage people from providing or assisting in providing abortions to people from states where it's banned. And we've seen some of examples of this. SB 8, the law in Texas, provides a private cause of action, basically enabling anyone to enforce the state's abortion laws. And what's interesting about SB 8 is that it is not geographically specific at all. So presumably it could extend to conduct and people totally in another state, and potentially subject them to liability in Texas, which could have discouraging consequences, not just because it's a judgment they have to pay, but again, particularly with medical professionals, because it can have implications for licensing and liability insurance and so forth. So this is a direction that I think will become especially important as we try to see, whether and how the United States can operate with this patchwork of very different abortion laws. And the law is really very unclear. There are few clear limits on states' ability to impose even criminal, but especially civil liability for out-of-state conduct. And this is something that the National Right to Life Committee is urging the creation of civil liability in a lot of states, or in some cases, the extension of existing doctrines to the abortion context to try to discourage movement of people across borders and try to discourage people in states where abortion is legal from helping those in states where it's not. And with that, I will turn it over to I think Elizabeth.
Okay, sure. Okay, so I think I'm here, I've been asked to talk a little bit about how to understand Dobbs as both in the criminal context and in sort of the digital world that we live in. So just a couple of quick points. So I think it's important to understand that the collection and the use of digital data is now a part of very ordinary criminal investigations. So everything from your location data, which can come from sources like license plate readers, which are everywhere, used by local law enforcement agencies all over the place, not very special or expensive or unusual. It can come from data sold from data brokers, which itself comes from all of those apps that you decided to download and you clicked through with the agreement, in which in the teeny tiny print said that your location might be collected and then sold to a third party, including law enforcement. All of your social media communications, all of your text messages, all of your emails. I would even include the growing number of just genetic information that is in the form of digitized profiles that is available for millions of Americans online today. All of that is now part of the world of digital information and thus potential digital evidence that is used not just for high-profile investigations, it's used for everything. And so, as has already been pointed out, now that abortion is no longer a fundamental constitutional right, it can turn into an ordinary crime. And so, wherever you are in states where abortion is either completely restricted as a criminal matter or practically completely restricted, that means that all of the things that are potentially linking folks to the crime of abortion becomes ripe as sources of potential evidence. So anything that you might do, online searches for things like out-of-state abortion providers, texts that are text exchanges between folks about how should I obtain an abortion, emails or online purchases regarding abortion medications, or even offers. These are all potential offers to help friends or family, to drive them to places, or to help them get advice. This is all potentially digital evidence. And the context here is that if we take the frame wider from abortion and Dobbs, the truth is that we live in a world in which we have very few protections for our digital data. There is a lot of criticism out there about the state of the world that we live in with respect to our digital privacy, but not a whole lot of action. So one of the things that's frustrating to me is to hear, well, if I say, look, there's a lot of information out there that can get people into trouble now that Dobbs is the law, folks say, oh, well, there's HIPAA, or there's the Fourth Amendment. And I always say, I've got news for you. HIPAA and the Fourth Amendment is not going to be helping you here. Your period tracking app, it's not really has very little to do with HIPAA. It's nothing to do with HIPAA. You think that a case like the 2018 decision in Carpenter is going to protect all of your digital data? Well, no, it's not. So we live in a world in which there's an enormous amount of data, and we have very little control over that data. And so I'm not even mentioning, of course, the possibilities for what you might call digital vigilantism. What I mean by that is that it's not only law enforcement agencies that might become possible investigators for the crime of abortion. Because of the highly politicized nature of abortion today, there are a lot of folks who are simply interested and have the time and the energy to trawl the internet to try and find if they can get people into trouble. This is not an analogous situation at all, but if you look at how many people were invested in becoming online sleuths to identify those who were involved in the January 6th attack on the Capitol, you know the amount of energy that people have if they feel devoted to a cause to find digitized information. And then finally, I want to point out that the burdens of this digitized surveillance after Dobbs is not going to be evenly experienced, right? So that means that if you live in a state where abortion is mostly or entirely criminalized, and you're the typical abortion patient, you're going to be especially vulnerable. We know that in those states, the typical abortion patient is a young woman, a low-income woman of color, and we know from all kinds of studies that those folks are in the most vulnerable position in terms of protecting their own digital privacy. So even though all of us experience this kind of vulnerability in the digital space, it's especially difficult to hear advice given to folks like saying, well, just delete your apps, or stop using your cell phone, or just don't search Google. I mean, that's just like saying don't live a normal life. So that can't be the solution for the world that we find ourselves in.
Great, well, thanks. And as I think all the speakers before me have indicated, the court's decision in Dobbs will have, and indeed is already having, really devastating consequences for women's health and women's equality more broadly, particularly as Professor Joe just said, for low-income women and for women of color. But in his opinion for the court in Dobbs, Justice Alito suggested maybe that the consequences stop there, stop with abortion. So as he said, nothing in this opinion he wrote should be read to cast doubt on other precedents, other substantive due process precedents, like the right to marry for same-sex couples, or the right to non-marital sexual intimacy should be cast into doubt because they do not, he said, raise the same concerns as abortion. The joint dissent in the opinion did not buy it. It seemed impossible, they said, to cabin the majority's reasoning and approach, they said, and to use their words, the majority's assurance that its decision will not affect associated substantive due process rights is like someone telling you the Jenga tower won't topple when they pull the bottom string out. So who's right? What will the consequences be of these other substantive due process decisions? If a direct challenge to some of these other cases, Obergefell, Lawrence, made its way up to the Supreme Court, I think the joint dissent was surely correct to suggest that those decisions are deeply, deeply vulnerable today. And indeed, some scholars have suggested that that is actually a feature, not a bug, of the court's approach to substantive due process in Dobbs. So in a forthcoming piece, Yale Law professor Rita Siegel writes that the substantive due process approach that the court used, as Professor Tang described, was invented for that very purpose. She writes that the purpose being to deliberately cast a wide shadow that threatens, weakens, discredits, and marks for possible overruling a host of other substantive due process decisions. You know, as she predicts, and as the joint dissent predicted, it's certainly possible that if a direct challenge to these other cases, to Obergefell, to Lawrence, even to Griswold, establishing the right to access contraception, were to make its way up to the Supreme Court, the court may reach the same conclusion. It may conclude that those rights, too, are no longer protected under the 14th Amendment. So to take same-sex marriage as an example, it's certainly possible that the court will overrule Obergefell. And to be clear, at least in that context, if the court were to do that, the consequences would be sweeping and immediate. So there are 35 states today in the United States, including the state of California, that still have marriage bans, some statutory, some constitutional. And if the court overruled Obergefell, those laws would boomerang back into effect, and same-sex couples would be banned from marriage in 35 states in the country. I think that's certainly a possible outcome, but I just wanted to flag something else that I think surely will happen, even before we possibly reach that point, and it's something that we have seen in the abortion context as well, which is really sort of death by 1,000 cuts. So sticking with the same-sex marriage example, I think we will continue to see efforts to chip away at the substantive protections extended by Obergefell. And indeed, we have seen that since the very day that decision came out. I'll share just two examples of the kinds of indirect attacks that I'm talking about. So one is a case called Pigeon versus Turner. And in the case, some private parties and Texas officials argued that while Obergefell required the state to allow same-sex couples to marry, it did not, they argued, require the state to accord the same rights and responsibilities to same-sex spouses as the state had to afford to marry different-sex spouses. The specific issue in that case was access to employment-based spousal health insurance benefits. And I think, as many of us here know, often those benefits are absolutely critical to the physical health and the financial stability of families. The other example is a case also out of Texas involving parentage. And it involves a woman, CW. CW and her wife had a child together during their marriage. Under clear Texas law, if she had been a man, it is absolutely clear that she would have been recognized as a parent of that child. But in the divorce proceeding, a Texas appellate court held that she was not a parent of their child. And the reasoning should sound familiar. The court said, Obergefell simply required that Texas allow them to get married, It did not require them to treat her and accord her the same rights that would be accorded to a different sex spouse. And so here I'll just quote, Obergefell did not hold that every state law related to the marital relationship or the parent-child relationship must be gender neutral. Now, to be sure, other courts have rejected this kind of reasoning, and some certainly will continue to do so in the future. But I think, given what we're seeing, I think we'll likely see ever more of these kinds of indirect attacks on the substantive rights of same-sex married couples, and maybe more of these kinds of decisions as well, as both state officials and private parties, I think, are newly emboldened in the wake of Dobbs. Again, if one of these kinds of cases, either the direct full frontal attack or one of these indirect attacks makes their way up to the Supreme Court, again, I think the court has given us reason to be concerned about the ultimate outcome. And actually, it might not take us very long to get some more clues about what the court would do in such a case. The court is actually poised to decide a case that has implications for same-sex couples this term in a case called 303 Creative, which has to do with a website designer who does not want to provide equal services to a married same-sex couple or the married same-sex couples, and claims that if the state were to apply the state non-discrimination law to her, it would violate her First Amendment rights. So stay tuned.
Okay. We're now going to take questions from the audience. So would anyone like to start with a question? Yes.
Since it appears we don't care about stare decisis anymore, what's to stop the next Supreme Court once it overturns to kind of going back and reversing this, or like, is that a hope we can have in the future? Right, anyone?
For these other substantive due process
Yeah, or
decisions?
protecting.
I'll start maybe and someone else can take it. So again, there is this line of substantive due process cases that don't involve abortion. They involve the right to marry for same-sex couples, the right to engage in non-marital sexual intimacy, also a line of cases related to access to contraception, as well as the right of parents to control the upbringing of their children. And the question is, as I suggested, are all of those cases now vulnerable in the wake of Dobbs? I think despite Justice Alito's claim that abortion is different, the joint dissent suggests that most of the opinion really is devoted to discussing an approach to substantive due process, and if you apply that approach to these other decisions, they seem very vulnerable, right? If we ask, in 1868, was there a deep history of affirmative legal protection for marriage for same-sex couples, or the right of unmarried people to engage in sexual intimacy? The answer could be no, and the court could overrule those decisions. It's possible one could say that the stare decisis argument is stronger in those cases. The court obviously was very dismissive of the stare decisis argument in Dobbs, and I think suggests that the critical question when thinking about stare decisis adherence to precedent is whether the court thinks it's egregiously wrong. And there too, if we apply that rule here, it seems like they might reach the same conclusion, that those decisions are also egregiously wrong. Justice Thomas certainly made that clear in his concurring opinion. They should all go. They must all be overruled. I think for those who believe those cases were correctly decided, Dobbs gives reason to be concerned about their interpretation.
Yeah, I've seen people try to draw a distinction, for example, with Obergefell and marriage by saying the reliance interests are different. But the court in Dobbs essentially just says reliance interests don't matter because you can vote. And so I'm not really seeing how that argument would apply with equal force. To the extent there's a distinction, it's more political. I think the court, there's various points in the opinion where the court essentially says there's been this, from the court standpoint, clear expression by states that oppose abortion, by a social movement that opposes abortion, that Roe is not a settled law, as Justice Kavanaugh put it. But it's easy to follow that playbook, right? You can, as Professor Johnson was saying, you can make the argument that Obergefell isn't settled law because states have been trying to circumvent it or ignore it, and social movements have rejected it, often the same social movement. So, I mean, essentially, if there's any obstacle, it would be, this is the legal historian, legal realist in me speaking, but I think it would be the court's unwillingness to do something like say there is no right for married couples to use birth control. I don't think that there's much in the way of jurisprudential obstacles, and I think on Griswold in particular, there's a concern that the line between abortion and contraception in the court's jurisprudence has not been clearly drawn at all. And clearly the strategy that anti-abortion groups are using in the states is to essentially contest that line in such a way that you don't need to introduce a law banning birth control. You can simply have a law banning abortion and in effect get rid of a lot of contraceptives in that way. But I think I'm not convinced stare decisis is going to be an effective tool of anything. It's going to be, if there's any point at which there's a fear of loss of institutional legitimacy great enough to move someone like Justice Kavanaugh, and whether that such a thing exists, I think is another question.
Okay, and before we go to our next question, you can see I'm leaning down here into my mic. If I can have all of our panelists move their microphones just a little bit closer so we can hear in the back of the room as well. And we have a couple more questions. I saw you had your hand up.
Hi, do you anticipate the shift to potentially using equal protection as an argument occurring, and how effective do you think that argument would be for these cases?
So we're talking about same-sex marriage, because it's hard to think of a strong equal protection argument in the context unless we think of warrants just as a rule applying to same-sex couples. So there's a possibility that even if the court were to say there's no substantive due process liberty and interest in the right of same-sex couples to marry, that the court could affirm the holding on equal protection grounds by saying that it discriminates impermissibly on the basis either of sexual orientation or on the basis of sex. So that's possible, and that's a way that maybe Obergefell remains safe, even in this world of a new approach to substantive due process. But I'm not sure it saves Griswold, access to contraception, rights with respect to children, parents over the control and upbringing of their children. And Lawrence, I think it depends on how we characterize that right. If it's one that's just about same-sex couples, then maybe we've got an equal protection argument. But if it's about unmarried couples and their right to engage in sexual intimacy, I'm not sure that equal protection does much work.
Yeah, I mean, on abortion, there's a lot of state constitutional work being done. And including in places, I mean, California obviously has Proposition 1, which is grounded in not only concerns about autonomy, but also equality. But it's worth emphasizing that state constitutional litigation is happening in places that don't have any protection for abortion now, probably the most salient being Michigan, where there's lots of moving parts in Michigan, but state constitutional litigation is part of it. So I would expect to see that while protection for abortion itself will take some time in the courts, the direction that that's going to head in state Supreme Courts to begin with, but eventually in a distant future where the U.S. Supreme Court might be amenable to such an argument, equal protection will probably be the direction that goes, in part for reasons that are probably familiar to some of you who are following this. There was a feeling that the autonomy arguments were not as strong as equal protection arguments, especially in isolation. And you see that reflected in the state constitutional briefs and arguments that are being made now in states with courts that may be willing to listen.
In terms of Congress's power to combat some of these state-level initiatives, where do we see that being most securely rooted? Is it through the spending power? Could Medicare for All, providing abortion services, preempt these incompatible state laws? Just a question.
The problem with the spending clause is that 30 states aren't going to take any money if you try to condition the receipt of federal funds on protecting the right to abortion. So I think the strongest basis, I think objectively, an unassailable basis is in the Commerce Clause, which is to say the provision of an abortion for sale is a classical sale of a commodity, a service for money. So under existing law, if you've taken common law One, right, under the Lopez, the third category, abortion. The act of providing abortion is an economic activity with a substantial effect on interstate commerce. Now, that doesn't mean that every statute creating a federal statutory right to abortion that tries to preempt a contrary state law would be upheld as a regulation under the Commerce Clause. So, for example, the Women's Health Protection Act, as it's currently written, the major piece of federal legislation on offer to codify a right to abortion, I think is susceptible to an argument that it actually isn't a regulation. That statute just essentially says there is a right for a pregnant individual to obtain an abortion and a doctor to provide an abortion. I don't know that we would say that when we create a right, we are regulating a practice. Regulation usually refers to restricting in some way a certain kind of behavior. So I think if conditions were to change, if we were to get 2 Senate seats and we could carve out from the filibuster in 2022, if we were to miraculously hold on to the House, Congress wants to be a lot more specific in how it wrote the statute. It could use, for example, Title VI of the Civil Rights Act as a model. It could say no abortion provider in the same way that no public accommodation can discriminate on the basis of race in the sale of goods or services. No abortion provider can discriminate on the basis of fetal age in providing an abortion. In other words, no provider can say, I can't provide you an abortion because the fetus is too far along gestationally. That would preempt any state law that requires abortion providers to deny abortion because of fetal age. So any state law would be conflict preempted. It would be a square regulation, right? You're telling a provider of a service that you have to provide that medical service for a fee to a person who requests it. That's a kind of an awkward situation because it treats the abortion provider as the unit of regulation. The Title VI analog is like the discriminatory restaurant or hotel who doesn't want to serve a black customer. That's obviously not what abortion providers are doing. So it looks odd as if we would want to include carve-outs to allow abortion providers who have moral or medical reasons not to provide. So, for example, Jackson Women's Health Organization in Mississippi only provided abortions up to 16 weeks in pregnancy, even though constitutionally they could do so up to 24 weeks. We want to provide carve-outs to allow abortion providers to make those choices. Otherwise, they would oppose the law. But there's ways to draw these statutes where it's just a square regulation of commerce, like the sale of a service. And if that's not allowed, if the Supreme Court were to say that that's not within Article 1 authority, we've got a lot of other problems.
I'm wondering, as the next generation of lawyers and current generation of people learning the law, what any advice or suggestions you have on what we can do as people who are going into this kind of chaotic environment? It's for anybody.
I'm a historian, I'm not usually in the what you should do business, but I mean, I can tell you what people have been doing badly that helped land us here, and I think conservatives have been very good at, one, not practicing this as single issue politics, right? So I think for a long time, after Casey happened and the court declined to reverse Roe, there was this intuition that what needed to change was how the Supreme Court did business, like how the Supreme Court, or even if the Supreme Court cared about popular opinion. The anti-abortion movement's involved in campaign finance law, they're involved in voting rights law, they're involved in a lot of other things because they see this as sort of about how the democracy works, not just up and down are people for or against abortion. So I think if this is something that interests you, you have to care about those other issues. So not just reproductive justice in the sense of other reproductive issues or social justice issues have to matter to you, sort of like voting rights and democracy issues should matter to you because that's been a lot of the work that's being done. The other thing I think that conservatives have done very successfully is that they've been very good at local politics, right? So being invested in and focused on things like who sits on school boards, who's elected to sheriff positions, who's controlling state legislatures. There was this transformation in 2010, especially in the American South and Midwest, which had not had Republican majorities in both houses of their legislatures really at all, to a point where those are effectively uncompetitive single-party states, right? And so that's important both because I think progressives have not been attentive enough to those issues. It's also important because a lot of these laws are vaguely written, and therefore what they actually mean in practice will be left in the hands of sheriffs and prosecutors, not governors, not senators, not the people who usually pay attention to. And so I think there's a lot of work and activism that can be done at the local level And that's true even in places like California. There are places in California there are places that are only served by Catholic or Protestant hospitals that don't make certain kinds of care available. I am weirdly in contact with the guy who's part of the Sanctuary Cities for the Unborn movement as a historian. Lots of people talk to me who shouldn't. He was telling me that he is planning on coming to California to try to get cities in California to ban abortion, to prompt challenges that would potentially land at the conservative U.S. Supreme Court. So there will be work to be done in progressive states, but of course there's work to be done in states where abortion is already criminal for people in states like California that interests you.
Yeah, I'll just follow up to say that I do think that working to enact the policies you want, even in California or in other more abortion-friendly states, I think it does have a really big impact because without some kind of national ban, it's really impossible to stop people from seeking care in other states. And the legal lines are really not clear, and there's more doubt, I think, about a state's ability to punish or impose liability on out-of-state actions than, that kind of goes both ways. It encourages states to try to outlaw people leaving the state, but it also means that helping someone, it's not really clear that criminal liability in particular, and even civil liability, can constitutionally attach. There are steps that states can take also to, say, avoid cooperating with investigations in anti-abortion states and so forth. So, even though I think often many things seem like a foregone conclusion in California, it's sort of not worth putting in the effort to strengthen protections further, I think that can have a really big impact.
I'll just follow up on the local stuff too. I mean, I think sometimes you see a decision like Dobbs and think, well, what can I do, right? Like, I'm not going to have my case before the Supreme Court or anything. But, as it's already been mentioned, there's so much at the local level that needs to be done, that needs to be paid attention to. So if you could ask yourself, when was the last time you were in your hometown public meeting for your local police department? If the answer is never, that's a place to start, right? I mean, and the reason why is because, I'll give you an example, there was a headline about the New Orleans Police Department that said, New Orleans Police Department said they will not be enforcing the state laws of abortion. You might read that and think, great, but you read it closer, and you say, but there is a mandatory policy of taking a report of every potential criminal abortion. And you think, well, what is that? That is a internal police department policy of creating data as a mandatory matter, even when it doesn't have to be. That's not mandated by the state, it's not mandated by any law. But, for local folks who care about those things, they can demand that their local institutions don't create these kinds of situations that will get people unnecessarily into further trouble. And so it seems like sort of sometimes like a boring thing, a simple, very local administrative matter, but those are the things that often have the first impact on individual life.
Yeah, and I mean, I'm going to be the old person who says vote, but there's also something to this too, because I mean, the politics of the local really matters. I mean, some of you may have followed that in Kansas, which is an overwhelmingly conservative state, voters decided I think quite clearly to retain the state constitutional right to abortion. That campaign was conducted with messages tailored to people in that state. And I think that there's pretty clear examples of politicians being afraid of losing their elections, retooling at least their public positions on abortion, right? I mean, I've had funny calls with reporters lately about Blake Masters, where people are like, Blake Masters supports a personhood amendment. Does that mean he's in favor of banning abortion? And I'm like, well, yeah, because that's what that means. It doesn't say so on his website, that's still what it means. So I think that there's signs already that notwithstanding the kind of eroding democratic norms we have, that political pressure works, and it works in surprising places. So if you're looking for places to do this kind of work, you may be able to make a difference in places like Kansas that you would first expect.
Yes.
I'm Marty West, retired faculty, but I want to point out the best thing about the Kansas vote was the polls were wrong. None of the polls predicted that victory. So the polls are wrong, and the Democrats are going to do much better this fall than the polls are saying. Dobbs is going to help the Democrats get 2 more Senate seats and maybe keep the House. And there are 4 congressional seats in California that went from Republican to Democrat in 2020, and a bunch of us are working hard for those 4 seats to go back to the Democrats in 2022. So go online, find out the 4 seats in California that need your money to help elect Democrats within 6 weeks.
In the back here.
So we've seen the court use a history and tradition test to expand rights that they like in Bruin and with gun rights, and contract rights they don't like in Dobbs. So basically, is there anything that lawyers, judges, law professors, law students can do to put pressure on judges that use this type of test and cherry pick history? And how do we kind of get to a point where our tests are not based on whatever Clarence Thomas likes the most that he found when he does his research?
I don't want to be too optimistic in responding to the question, but there are, this term, there could be some, listen, history and tradition is here to stay. Traditionalism is here to stay. I don't want to call Dobbs originalist, but originalism as a separate thing is here to stay just because there's an advocate for it at the Supreme Court. And so as lawyers and professionals, as academics, we would be negligent if we did not try and clothe our causes, the interests that we have in those same arguments moving forward. So I'll give an example. There is a huge personal jurisdiction case at the Supreme Court this term. It involves the question, everybody here remembers Daimler versus Bowden, right? So you cannot sue a large multinational corporation in California, even if it has billions and billions of dollars of sales here, dozens of offices here, if it happens to be incorporated in Delaware, right? So even if, it's no burden at all for the company to come to California to defend the suit, it's very burdensome for you to travel to Delaware. You're out of luck, you have to go to Delaware to sue. Pennsylvania has a statute that says a foreign company that wants to do business in Pennsylvania has to consent to general jurisdiction here, right? So if a Virginia railroad injures an employee in Virginia and that employee retires, he develops cancer because he had to work with asbestos, and he now lives in Pennsylvania, he doesn't have to travel all the way to Virginia, he can sue in Pennsylvania. Big question about whether that violates the due process clause. And so the progressive lawyers who are arguing on behalf of this individual plaintiff seeking access to courts, civil justice against a large corporation, are arguing that the original public meaning of the 14th Amendment would have allowed precisely this kind of statute requiring the company to consent to jurisdiction. Will it work? Maybe. Actually, Neil Gorsuch has suggested he's open to that argument. Clarence Thomas joined the concurring opinion that Gorsuch wrote. Right? It's a low salience issue. It's not abortion. It's not guns. It's general personal jurisdiction. But it's meaningful, right? So we got to take the wins where we can get them. Doesn't I don't think should be a cause for huge optimism, but maybe a little bit.
Yeah, I mean, I'm as a historian, I'm hesitant. I mean, I did one of the historians' briefs in Dobbs. I was helping the people on the other historians' briefs in Dobbs. There's an overwhelming consensus among historians that the history in Dobbs is bad. The main historian cited by the courts in Dobbs is not a historian. He's an expert on land and water law who wrote a grand total of 1 book on history, which happened to be about abortion, which is not cited. I mean, his entire amicus brief is how no other historians cite him. And it may just be a funny coincidence, or it may be because the consensus is that he's wrong. I mean, I think that on high salience issues, that the main purpose of doing the kind of tradition in history argument is to generate a record that for future courts that this is not, that when you can invoke history and tradition without practicing history or tradition, which is I think what Dobbs was doing. And I think there's a virtue in that. I wouldn't expect necessarily the court to respond to that when the court is ignoring overwhelming and obvious consensus among, really across a bunch of different historical disciplines. There's not much reason to believe that better historical evidence will persuade this particular group of justices, but, a better historical record it's kind of like high quality dissent, right? I mean, you're writing to the public, you're writing to the future, you're not necessarily writing to the people in a position to issue decisions next term.
Yeah, my question is kind of bouncing back to the potential domino of reproductive. We released in the comment we didn't really get to this whole bacon credit clause, and also the age that I was at when Roberta happened is I don't remember what it was like before Roberta. So if that domino were to fall, what does that look like in terms of people wandering around to different states trying to get legal?
Great question. So as I said, There are 35 states today that have either statutory and/or constitutional bans on their books. Some of them might have been struck down under state constitutional provisions, but most have not. So most of them, if Obergefell were overruled, would go back into effect, and would boomerang back into effect, just like we're seeing with old abortion laws that had been understood to be unconstitutional. In terms of the interstate effect, so if someone, there would still be states that allow couples to marry. If somebody went to one of those states and got married, the question is, would other states have to recognize the marriage? And the full faith and credit clause actually has not that much to say about that. So the full faith and credit clause requires states to grant exacting full faith and credit, exacting recognition to judgments of courts, but you don't go to court to get married. So it's not understood to fall within the scope of that rule requiring exacting full faith and credit, and instead is understood to be a public act or record for which there is a public policy exception. And that has long been the common law rule about marriages, that states can refuse to recognize a marriage that violates the public policy of the home state. So, I mean, certainly there'd be litigation. We could try to make arguments, maybe equal protection arguments, that they're recognizing other kinds of marriages, but not marriages involving same-sex couples. But the full faith and credit clause certainly, in and of itself, does not clearly require states to recognize the marriages. I mean, there's an issue too with people who are already married. I don't think overruling Obergefell would have an effect on existing marriages, and we did have litigation here in California that was similar when we voted to amend our constitution after some couples had already married, and our state high court held that that change in law did not have any effect on the existing marriages. And I think even under Dobbs, there's still a strong argument that there are very strong reliance interests of those people who are already married, and those reliance interests are of the ilk that Justice Alito claimed, at least in Dobbs, are of greater importance to him because they're more concrete property and contract related reliance interests. So I think existing couples are safe, but couples should not assume that those marriages will necessarily be recognized across state courts.
Yes. I think I'm kind of curious. It feels like some states are empowering average citizens to then, be actors in this big scheme of things, which to me feels very reminiscent of like the slave patrols and states offering awards for people turning in free slaves and sending them back. And so I'm curious, like, what is the legal angle of this not just turning into like, especially in the sense that we know like people of color are very much impacted greatly with laws like this. So like, where are we going?
Yeah, I mean, I know. So there was some sense that maybe that was going to be a dead end because the anti-abortion movement since at least the 90s has been fixated on incarcerating people. And so the SB8 model, the like you can sue legally for a bounty model, is still a civil model, so it wasn't clear they were going to be that interested in that. But now that they want to do the kinds of things Professor Flory was describing, so in other words, saying, if you were performing an abortion on someone from Texas and California, or you were helping someone, and then, you can be sued anyway, there's now, this model's been revived, the bounty model, for people essentially for getting over concerns that this might violate a right to travel, or that this might raise choice of law concerns. So I don't know how far it's going to go, but literally the same people who wrote SB8 are now trying to do workarounds so people can regulate out-of-state conduct. Your fear about, criminally punishing pregnant people of color is a real one too. We already know that happened when Roe was on the books. Usually not for abortion, it was usually for drug abuse or alcohol abuse or other conduct during pregnancy. But there's now a rising movement, it's still a minority movement, but it's a real thing in the anti-abortion movement to criminally punish people for having abortions, right? And we know overwhelmingly that would be people of color who would be punished. I don't know yet how much that's going to happen. That's something that I think is a kind of TBD even in conservative states, but it's something to keep an eye on.
Yes.
We
talked a little bit about like legitimacy of the court and the court's approval rating being like historic lows. Do you think there's any chance they take into account like what, you know, the views of Americans and what the, you know, take those into account to their decisions?
I mean, I think that at least the understanding of the social movements I studied is that the people who are on the court now were chosen in part because they wouldn't respond to concerns about popular opinion, right? There was a lesson, I think, if you are in archival material about Clarence Thomas, the celebration of Clarence Thomas was not that he was originalist, textualist, or conservative, it was the way he responded to the sexual harassment accusations raised by Anita Hill, essentially that he was not concerned about backlash, he was not concerned about scandal or controversy. And at least people in the anti-abortion movement saw that as a proxy for how he would respond to public outcry about other decisions he would issue, right? I don't know, I mean, I think that there are limits on that. I mean, I think Justice Kavanaugh has some, you know, modicum of concern about how he's perceived. Justice Barrett hasn't written enough opinion. I mean, she may have some concern about that, which may be why she's writing so infrequently, beyond, you know, the kind of idiosyncrasies of how opinions are assigned and so on. But I would be not very sanguine about that, in part because I think the justices perceive themselves as adhering to the right method of interpreting the law, even at the expense of popularity. And I think that they were chosen partly with an eye to that being their response.
This will be our final question. Thank you.
Oh, that's a lot of pressure. For Professor Joe, protecting data, very interesting. So, especially today with the FTC doing nothing, and companies like Facebook and Twitter continuing to reign, what's the best way to protect our data? You know, is there liability with private consumers creating apps to prevent data from being disseminated to these companies to then be used as potential evidence?
So, I mean, as I mentioned earlier, we're kind of in this uncertain world, and I think, you know, this today's panel is about Dobbs. Really, my point is about digital privacy more generally, which is basically we have very little. So I think the thing to focus on with respect to abortion rights is to think, well, why not, you know, put more impetus behind proposed bills for protecting digital privacy at the federal level, you know, with new urgency. Because there are lawmakers who have been pushing bills to either update things like the Stored Communications Act or to address new parts of digital privacy, like, you know, what I didn't mention is that the fact that the federal government says that we don't need the Fourth Amendment restrictions when we buy data, because we're just like consumers in the marketplace, so we can buy as much data as we want, and nothing holds us back, right? So there's the Fourth Amendment is not for sale, proposed bill from Senator Wyden. All of those should be understood as, once you protect everybody's rights, it also protects digital reproductive rights as well. So it's no longer just a specialized, like, nerdy data privacy issue. I think it has real, you know, consequences for anyone, because like as I mentioned before, you really can't tell people, well, then just don't use Facebook, or like don't text people, or, you know, like if you want to talk about abortion, you know, drive over to your friend's house and do it, because even your movements, your location is something that's very easily tracked.
Okay, thank you everyone for coming, and thanks to our